Hello, I'm Constitutional Attorney Catherine Henry, and this is our Florida State Constitution series, where I'm going to read to you the very words of the most important sections of the Florida State Constitution. It's not really unusual compared to a lot of other state constitutions. There are 12 articles in the Florida State Constitution. That is a total of 213 sections. That's a lot of sections. And it totals to approximately 49,500 words. And the U.S. Constitution has approximately 8,500 words, including all of the amendments. So the Florida State Constitution is almost 6 times longer than the U.S. Constitution. And that's quite a bit. Now, I would say to you that you definitely need to read the entire thing start to finish, definitely at least once. I would say at least once every decade if you're a Florida resident. But do I think that most of you are going to do that? No. And are you going to watch a video of me reading all those boring words to you, especially the super droning on parts that I even struggle staying awake just while reading to you? No, I don't think it would be a productive use of my time to create a video for you like that. But I do want to make sure that you are really listening to the words of the Constitution in those vital parts. So, for example, I am going to read to you every single word in Article 1. Why? Because Article 1 is our Declaration of Rights. In our state constitution, that, in my opinion, is the most important part of our state constitution. But there are other vital sections that I think you need to know about. And so we're going to go over those in this video series. Let's go ahead and get started. We, the people of the state of Florida, being grateful to Almighty God for our constitutional liberty, in order to secure its benefits, perfect our government, ensure domestic tranquility, maintain public order, and guarantee equal civil and political rights to all, do ordain and establish this Constitution. Article 1, Declaration of Rights. Section 1, Political Power. All political power is inherent in the people. The enunciation herein of certain rights shall not be construed to deny or impair others retained by the people. Section 2, Basic Rights. All natural persons, female and male alike, are equal before the law and have inalienable rights, among which are the right to enjoy and defend life and liberty, to pursue happiness, to be rewarded for industry, and to acquire, possess, and protect property. No person shall be deprived of any right because of race, religion, national origin, or physical disability. Section 3, Religious Freedom. There shall be no law respecting the establishment of religion or prohibiting or penalizing the free exercise thereof. Religious freedom shall not justify practices inconsistent with public morals, peace, or safety. No revenue of the state or any political subdivision or agency thereof shall ever be taken from the public treasury directly or indirectly in aid of any church, sect, or religious denomination, or in aid of any sectarian institution. Section 4, Freedom of Speech and Press. Every person may speak, write, and publish sentiments on all subjects, but shall be responsible for the abuse of the right. No law shall be passed to restrain or abridge the liberty of speech or of the press. In all criminal prosecutions and civil actions for defamation, the truth may be given in evidence. If the matter charged as defamatory is true and was published with good motives, the party shall be acquitted or exonerated. Section 5, Right to Assemble. The people shall have the right peaceably to assemble, to instruct their representatives, and to petition for redress of grievances. Section 6, Right to Work. The right of persons to work shall not be denied or abridged on account of membership or non-membership in any labor union or labor organization. The right of employees by and through a labor organization to bargain collectively shall not be denied or abridged. Public employees shall not have the right to strike. Section 7, military power. The military power shall be subordinate to the civil. Section 8, right to bear arms. The right of the people to keep and bear arms in defense of themselves and of the lawful authority of the state shall not be infringed, except that the manner of bearing arms may be regulated by law. There should be a mandatory period of 3 days, excluding weekends and legal holidays, between the purchase and delivery at retail of any handgun. For the purposes of this section, purchase means the transfer of money or other valuable consideration to the retailer, and handgun means a firearm capable of being carried and used by one hand, such as a pistol or revolver. Holders of a concealed weapon permit as prescribed in Florida law shall not be subject to the provisions of this paragraph. The legislature shall enact legislation implementing Section B of this section, effective no later than December 31st, 1991, which shall provide that anyone violating the provisions of subsection B shall be guilty of a felony. This restriction shall not apply to a trade-in of another handgun. Due process. No person shall be deprived of life, liberty, or property without due process of law, or be twice put in jeopardy for the same offense, or be compelled in any criminal matter to be a witness against oneself. Prohibited laws. No bill of attainder, ex post facto law, or law impairing the obligation of contracts shall be passed. Imprisonment for debt. No person shall be imprisoned for debt, except in cases of fraud. Searches and seizures. The right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures and against the unreasonable interception of private communication by any means shall not be violated. No warrant shall be issued except upon probable cause, supported by an affidavit, particularly describing the place or places to be searched, the person or persons, thing or things to be seized, the communication to be intercepted, and the nature of evidence to be obtained. This right shall be construed in conformity with the Fourth Amendment to the United States Constitution, as interpreted by the United States Supreme Court. Articles or information obtained in violation of this right shall not be admissible in evidence if such articles or information would be inadmissible under decisions of the United States Supreme Court construing the Fourth Amendment to the United States Constitution. Section 13, habeas corpus. The writ of habeas corpus shall be grantable of right, freely and without cost. It shall be returnable without delay, and shall never be suspended unless, in case of rebellion or invasion, suspension is essential to the public safety. Section 14, pretrial release and detention. Unless charged with a capital offense or an offense punishable by life imprisonment, and the proof of guilt is evident or the presumption is great, every person charged with a crime or violation of municipal or county ordinance shall be entitled to pretrial release on reasonable conditions. If no conditions of release can reasonably protect the community from risk of physical harm to persons, assure the presence of the accused at trial, or assure the integrity of the judicial process, the accused may be detained. Section 15. Prosecution for crime, offenses committed by children. Subsection A. No person shall be tried for capital crime without presentment or indictment by a grand jury, or for other felony without such presentment or indictment or an information under oath filed by the prosecuting officer of the court, except persons on active duty in the militia when tried by court-martial. Subsection B. When authorized by law, a child as therein defined may be charged with a violation of law as an act of delinquency instead of crime, and tried without a jury or other requirements applicable to criminal cases. But any child so charged shall, upon demand made as provided by law before a trial in a juvenile proceeding, be tried in an appropriate court as an adult. A child found delinquent shall be disciplined as provided by law.